Okay, and I do see the cameras. Can people hear me right now?
And then with, I guess there's some numbers there. We'll have to find out who they are.
Okay, we are on record, Your Honor.
On record, we'll call the 8:15 compliance calendar. Let's go with Mr. Westbrook.
Your Honor, it appears that we've got some non-compliance issues. Looking for a victim impact panel, alcohol treatment, and jail.
Mr. Westbrook, good morning. Are you able to hear me?
Yes, Your Honor.
That's did you hear what the prosecutor had to say?
Yeah, I emailed a copy of the victim impact and the ADIS program. I did sign a release when I did it back in March, but apparently you guys didn't get them.
I'm looking at is this where you've signed up for school online. Looks like $35 was owed, but yes, how about the rest of it? How about the day in jail?
We've still been waiting to see. I don't know if the jail's been opened up yet. I've been waiting to hear about that.
They are open.
Okay, well, I'll take care of that this weekend or as soon as I can. As far as the compliance for treatment, I'm supposed to be completing this month. I don't know why he hasn't sent you any letters. That's beyond me. But then again, it took this guy 3 months just to send me insurance information.
Mr. Westbrook, sometimes what has to happen is you have to actually extract the reports, the proof from the treatment agency and get it to us yourself. They aren't very good about filing what they need to file. They're good about treatment, but sometimes the other goes lacking.
Yes. Go ahead.
Mr. Westbrook?
Your Honor? Yeah.
Is the day in jail something you can do in the next 2 weeks?
Yes, I can do that.
I'm not sure if you're going to need anything new from us to serve the 1 day. Sometimes the order, which was entered back on October 3rd of 2019, may not be effective anymore. You may have to come in and pick up an amended order. Check with the jail and see.
Okay.
You know how to get a hold of the jail by telephone?
Yes, Your Honor.
456-4509. Give them a call.
450.
See what they need. Make arrangements. Make a reservations. We need to get that done. What we're going to do is send you another court date for 2 weeks down the road. I'll expect you to have this back on track by then.
Okay, sounds good.
Mr. Westbrook, thank you for appearing. You take care of yourself. You have a good day and good luck to you.
Thank you. You too.
Mr. Dilly, any?
Nothing further, Your Honor.
Mr. Westbrook, that concludes the hearing. You can sign off. We'll go to the next case.
We have Mr. Brandon Wolf.
Yeah, go ahead and turn him on. Mr. Wolf, are you able to hear me?
Yes, I am, Your Honor.
Good morning. We're going to call your case now. It looks like what we're looking for is a alcohol assessment, a victim impact panel, and alcohol and drug information school. City, have any input?
Well, it looks like an SOC. Part of the agreement was that we would have all these things taken care of within a certain period of time, and it appears that we're cutting a little short of the cup. City could just simply revoke the agreement and close the case. That would be city's preference, and then Mr. Wolf is free to finish up whatever he needs to finish up with the court, and we'll be done.
Mr. Wolf, did you hear that?
I did. I just don't. What is an SOC?
Pardon?
What is an SOC? I think is what he said.
Stipulated order of continuance. What you did have was it looks like an agreement under the terms of which the matter was continued for a period of time. on conditions, and one of the conditions were just what we went over in the first place, do the alcohol assessment, the victim impact panel, and the alcohol and drug information school.
Okay, because I signed my release over. They have all of my information, and I've called, left messages. I've even showed up because I'm going through the CMAR behavioral here in Yelm.
So what you're saying,
And
you've actually done what you're supposed to do, you just don't have proof on file.
no, like I haven't even been able to start it. No matter how many times I've called, showed up in person, and everything, we just haven't gotten the ball rolling. I've asked them a couple times why, and they said they're still waiting on information. But I already gave them all of my pay stub information. I don't have insurance, so it's going out of pocket. And I already signed the release for all my court information. I really am confused on why.
Mr. Wolf, the city is moving to set aside the continuance with a reduction. I'm not able to find a copy of it. There's not a copy of the SOC in the file, but I presume that would have led to a reduced charge. That would have resulted in a neg 1 charge, which is much, much less serious than a DUI in terms of impact on your license, et cetera, et cetera. Mr. Wolf, you've got a lot on the a lot at stake here. The city has moved to set aside the SOC and enter a finding of guilt on a DUI, which would result in the suspension of your license, ignition interlock requirements, at least. What I'm going to do is set the matter for a revocation hearing 2 weeks hence. Now, you're entitled to have a lawyer at that hearing, Mr. Wolf. Were you represented by Mr. Haverco? The docket indicates that you were. I'll want
Yes.
to be here to assist you with the matter, but you've got a lot at stake here. The difference between a neg 1 conviction and a DUI conviction is there's a chasm there. A DUI conviction in terms of impact on your life is and your driving career is worse than a lot of felonies. It's time to make sure you get this, get what we got to get done. Okay.
Yes, Your Honor.
We're resetting it 2 weeks for a revocation hearing. We'll talk to you then.
So if within the 2 weeks, if I get the ball rolling a little bit more on this through the alcohol assessment and everything, would it still be able to go to a neg 1, or is that out the window at this point?
Not out the window at this point. I haven't ruled on that. I'll hear from you and I'll hear from the city and make a decision then. But you're not gonna do yourself any favors by not bringing yourself into full compliance. Okay.
Yes, Your Honor.
Mr. Wolf, I'm signing a document resetting the matter to July 8, 8:15. You take care of yourself and we'll talk to you then, okay? Any questions at all?
No, Your Honor.
Good luck to you. Take care.
You have a great day.
And you as well.
Bye.
Morning, Judge.
Travico, good morning. I trust all is well with you.
It is, Judge. Thank you. I am here at the Nisqually Jail. I've had an opportunity to meet with Ms. Wells and discuss with her case. And we are prepared to proceed. She would like me appointed, and then as part of that, we're going to waive formal arraignment. She does understand her rights with regard to an arraignment, to be read the charges and the rights that she has. She understands all those. And as part of that, it's her intention this morning to enter a plea of guilty to the charge. I've gone over a statement of defendant on plea of guilty, which I prepared yesterday, but I have reviewed with her today, and she does understand her rights and everything that's going on, and she understands the charge and just wants to proceed and hopefully be released today.
What I want to make clear for the record is I do know Sarah Wells from the Squally Tribal Court. If either she, yourself, or Mr. Dilly has any objection to me hearing the case, based on that, I'll gladly step down. City has indicated no objection. Mr. Haverco?
Thanks, Judge. There would be no objection from either myself or Ms. Wells.
Ms. Wells, are you able to hear me?
Yes, sir.
And your full name is Sarah Roberta Wells, is it not?
Yes, it is.
I'm looking at a statement on defendant on plea of guilty to one count of criminal trespass, first degree. Have you gone over the plea form with your attorney?
Yes.
And do you have any questions you'd like to ask me about what it meant to enter a plea of guilty?
No.
If you enter that plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing which could be up to 364 days in jail and or a $5,000 fine, the offense being a gross misdemeanor. With that in mind, as to one count of criminal trespass, first degree alleged to have occurred within the city of Yelm on September 4th, 2020, how do you plead, guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty? Accept the recommendation as to sentence?
No.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the Bless you.
Thank you.
The recommendation, Mr. Haverco, is, I understand it, is 364 days in jail, all suspended on the condition of law-abiding behavior. Is that correct?
Yeah, it is. The only caveat to that is, Judge, as a matter of routine, the city will recommend a fine. I would ask the court in this case to waive a fine. She's 24 years old, and she has a son that lives with her grandmother. And we were chatting a bit about, when's the last time she worked, and I was asking her questions about her financial ability to pay, and apparently she's never worked. So my thought was, gosh, I don't know that she's going to be in a position to ever be able to pay. So, which doesn't really help to send something to collections on something that's never going to be collected. So that's the only thing I would request is court follow all the city's recommendations, but just not impose a fine.
Mr. Dilly, on behalf of the city,
City has no objection.
I am aware, knowing something of Ms. Wells' history, she's never held a job of any kind.
Okay.
Ms. Wells, you have a right to tell me anything you wish. Is there anything you think I should know? I'm going to follow the recommendation. I'm going to let you know that. But if there's anything you'd like to tell me, go ahead right now.
I have nothing on top of my mind right now.
Hey, Ms. Wells, I'm going to wish you the best of luck. 364 days in jail, all suspended on the condition you have law-abiding behavior. And that would include not going to premises where you're not wanted.
Okay.
did not want to hold you in custody on bail, but I felt that that was the only way I had of getting you to appear in court, given the number of times you've failed to appear before. Unless you have some other hold on you, you will be released this date. Okay,
Okay.
any questions at all?
Thank you, Judge.
Ms. Wells, are you okay? Any questions?
No, thanks. Thank you.
Thank you. We'll move on to the next case in a minute.
Go ahead, hang on. You like this one?
We have a phone number ending in 4764. We don't have a name to go with that. If you could tell us who you are, we can call.
My name's Kristen Evans.
Could you repeat that?
Kristen Evans.
Oh, Ms. Evans, good morning. How are you?
I'm not too bad. How about yourself?
It looks like you were on one of these 90-day diversions on a theft charge, and which was going to result in a dismissal if you did what you were supposed to do.
Yeah, which I'm confused because I did the online thing, and that was the only thing that was asked of me, correct?
That's what I understand. You need to do the online theft school, or theft,
Yeah,
whatever it's called, and you haven't done that yet?
I did do that. Yeah, I mean, this was a few years ago, I think. Yeah, it's 2017, I think.
We don't have any proof that you did that.
I mean, I paid for it and everything. You had to pay for it before you could do it.
Now, is this
It-
have a receipt or?
You know, my life has been so chaotic since that. I can try to maybe see if I can find it online, but probably not in my paperwork.
So the question is what do we do now? Does the city have any feeling to give her another chance to do that, or close the case, or what?
Well, I guess now we will simply charge her with theft third. So I don't have any issue. Of course, it's 2017, so we're talking.
It's got a little
4 years ago.
little moss on it.
I have no objection to doing it, for giving her another 90 days. And if that's not done, then we'll just simply charge her with theft third.
Ms. Evans, that's the way things are. The city could note you up for an arraignment, have you come in, plead not guilty, and work out the best plea bargain, or go to trial. That would be your choice. However, the city's going to give you another 90 days within which to do the class and file proof that you've done so. Is that going to work?
Yes, it will. Can I have that website again that I go to?
We can certainly send that to you. Yes, we will send that to you with
Okay.
a copy of. Okay.
Okay.
How has life been going otherwise?
Pretty chaotic. My husband committed suicide, and so it's just been one thing after another. But and I fell into, back into drugs and alcohol, and I'm pulling myself back up. That's why it's taken so long for me to contact you guys to get this taken care of. But I'm just trying to take care of my life the right way now.
Right, one thing at the time. I don't see any new theft-related charges on your record here. So what we're going to do is send you the information on the website that you need to go to, and a copy of today's order. Ms. Evans, I'm going to wish you the best of luck. And if you've brought yourself into compliance, the city will dismiss. If you haven't, you'll need to appear at the next hearing, which will be 90 days from now, okay?
Okay. Thank you very much, Judge.
Ms. Evans, thank you. You take care of yourself. Thank you for appearing.
Yep. Thank you. Bye.
Goodbye.
Bye.
And then we can do, yeah. 0572.
We have a phone number ending 0572, but we don't have a name to go with that. If you could unmute yourself and let us know who you are, that'd be great.
Yes, Your Honor. This is Anthony Skinner Pratt.
Ms. Skinner Pratt, how are you doing?
I'm doing better. I was in the hospital yesterday. I kind of had a relapse from treatment.
That happens. That happens. The important thing is how you're doing now, I guess.
What was that, Your Honor?
What we're looking for is how you're doing in treatment? The last thing we have was filed June 7th, earlier this month. Anthony was discharged from treatment on 6/6 for committing a rule violation. His expected completion date was to be on June 11th. Have you been in contact with CMAR?
Actually, I'm actually through, hold on, St. Peter's Chemical Dependency Center.
Hey,
And yes, I have been in contact with them. I have a class today.
Based on the email we got regarding you being in the hospital, I'm a little concerned about your health here. I'll hear from the city if the city has any suggestion.
Why don't we go ahead and renote this for 30 days and see if we can't get back in compliance?
I'm tempted to go for 60.
60 is fine.
Mr. Skinner-Pratt, the important thing is you re-engage in treatment. Relapses happen. The road to recovery is not a smooth one. It's not without its speed bumps. Hey, as I've said many times before, it's not how many times you fall down, it's how many times you get back up. We're going to re-note you for another hearing 60 days from now, and I'm hoping you're going to be back. We'll take another look at your case then. I'm hoping you're going to be back in compliance, okay?
Okay. Thank you, Your Honor.
Is that going to work?
That will work.
Good luck. You take care of yourself, and we'll talk to you in a couple of months.
Okay. You have a good day, Your Honor.
You too. Take care.
Will,
Take that matter.
we're on, Your Honor.
Good morning. Call the matter of Yelm versus Nolan Navlet. I understand Mr. Navlet and Mr. Leone are online.
Present, Judge. Lorenzo Leone for Mr. Navlet. I am doing double duty between Your Honor's Court and Thurston County Superior, so I may have to answer the call the calendar there. But this matter comes on for a change of plea to a negligent driving. The charge of hit and run attended is being dismissed upon entry of the plea. I've gone over the plea form with Mr. Navlet. I believe he makes a knowing, voluntary, and intelligent decision to waive the important trial rights he has today. We will enter the plea if Your Honor will allow us to do so.
Good morning again. And if you did need to go to Superior Court, just let us know. Swing out. We'll put you on hold here, and we'll get back to you as soon as you're done.
Thank you, Judge.
Mr. Navlet, I've heard your attorney. Do you agree with everything he said?
I think so. I hopefully will come to it.
Mr. Navlet, are you able to hear me?
He just muted himself. I wonder if he.
You may be muted. You may need to unmute yourself.
It's the attorney, Your Honor, that is muted. He muted himself, the attorney, so I wonder if they went to the.
They had to go to, okay. Brett, the attorney muted, which meant he's had to jump over to super court.
Gotcha.
We will.
So Judge, my client just called the office. He's having some trouble, so maybe we should foot this for a moment.
Okay, that's, yep. We'll put you on, we'll check back with you from time to time here, and as soon as he's able to attend, we'll come back to you.
Thank you, Judge.
On the matter of Yelm versus Jaslyn Johnson, I'm looking at a motion to exonerate a bond forfeiture. I understand.
Your Honor, Ken Blanford here on behalf of the bonding company. Can the court hear me?
Yes, I can. Good morning.
Morning, Your Honor. Sorry for that. Your Zoom looks different than other courts, so I was a little concerned. Your Honor, this is not a completely unusual circumstance. What happened in this case was the defendant failed to appear. The bonding company paid the forfeiture. The bonding company then went and hunted down the defendant. Now, what is a little unusual is they presented her to the Pierce County Jail first. The Pierce County Jail is not taking, I think they're taking Class A felonies, but they're not really taking anyone. What then happened was the Secret Service grabbed her and brought her to the SeaTac detention center. I don't know exactly what she's accused of in the SeaTac detention center, but if the Secret Service is grabbing you, in my experience, that means things aren't going well for you, and you're likely going to be in custody for a while. My problem in a case like this is the purpose of bail and the purpose of these forfeitures is to get the defendant back to you. And in this case, the bonding company has done virtually everything they can. They found her, they got her. However, the problem is the federal government has stepped in and said, no, we want her more than you do. And we have no way of fighting it out with the federal government in that situation. Now, I suppose it's conceivable that your court could issue a transfer order, but to be frank with Your Honor, I don't know that that would be honored given the municipal court nature. So we're in this kind of middle ground. And so I think what we ask for is a partial refund. They've done the best they could in this situation. They've been partially successful, but frankly, the federal government is thwarting them and thwarting the court, but there's nothing either one of us can actually, in my opinion, do about that. So I think that's what we're asking the court to do.
I think this is the first time I've ever heard the possibility raised in a bond forfeiture issue. I'll hear from Mr. Dilley, response.
I have no response, Your Honor.
Well, you know, I reread the Hampton case, which seems to be the kind of the lead case in the history of the 1019. That's the one thing that occurs to me and that I've looked for is I can never find a case where they construe the return to the jurisdiction language and whether the impossibility is a defense or not. Yeah, in that case, the bonding company spent $3,000 to chase down the defendant to Indiana and brought her back out to Washington where she was within the jurisdiction. I could look at the case from a standpoint, I don't have jurisdiction. I think the Secret Service, if they didn't just round file any request from me to transport, would laugh. I certainly don't have jurisdiction over them. On that basis, I am sympathetic to the bonding company, and the bonding company has always been pretty good with this court about paying forfeitures when due. Again, I've never heard the defense of impossibility raised, but I think I am kind of persuaded that the bonding company has done the best it can and was kind of frustrated by the COVID responsibility and the Secret Service intervention. And yes, I certainly agree with you, counsel, there that the Secret Service wants you bad enough to grab you. You've got a lot of bigger problems in here. I'm going to cut the baby in half, so to speak. I'll order the refund of half the 2,500 if the city has no strenuous objection to
No
that.
objection, Your Honor.
And that's more of an equitable thing. If I was to go strictly by the case law and the rule, I don't have jurisdiction, and so the bond remains forfeit. But I think that's the appropriate thing to do here.
And Your Honor, if you want, I think, so I think there's case law that actually completely supports your position. There's, so first off, you have complete discretion here, and absent an abuse of discretion, you can't be overturned. But I think there's a case out of, I believe, Skagit, Your Honor, that involves deportation. And really what the court hung its hat on there was when the court knew the defendant was in federal custody, because effectively what could happen is, and it's kind of a, an impossibility situation where the feds grab the defendant, put him in CTAC, and then deport him. And the question is, when did they know? Could they have done a transfer order? Now, I think the Court of Appeals was a little bit in their ivory tower that day, because they kept talking about how the state could request the transfer. But I don't know that the federal government would actually follow those rules, given that they're trying to deport someone. But that was what the Court of Appeals did, and I think that's supporting of your position. So if the court wants, I can send a letter to the court with the citation for that, if the court wants to look at it.
I would like the citation. I agree with that first one. In the Hampton case, that was one of the problems the Supreme Court had. The judge denied the motion without giving any reason at all. Didn't explain why he exercised the discretion he exercised. I would very much appreciate the citation to that case. I'm not familiar with that.
I don't have it in front of me, Your Honor, but I'm going to be out of town for the next 2 days, but I'll write up a letter and send it to the court, and the court can take a look at it, because I think it does support the position of, at some point, the court gets put in these awkward situations, and the question is, what do we do? And the short answer was the Court of Appeals said, well, look at the facts and make a decision. And so I think your position is supported. So I will forward that on to the court.
You want to send an order to that effect down there, and maybe email the citation if you come across that, that'd be much appreciated.
Okay. Does the court not have an order from Aladdin on the $2,500? I was thinking the court can just strike the return amount, make it $1,250 or $1,220, $1,250, or I can just forward an order to the court.
If you'd prepare an order to that effect, that'd be great.
Perfect. I will send that on to the court today, Your Honor.
One pager would do.
Yep, absolutely. Thank you so much, Your Honor.
Thank you, and take care.
You too. Bye, Your Honor.
Oh, Mr. Leone is raising his hand. I think he's ready now.
Okay. Go back to Yelm versus Nolan Navlet. Mr. Leone, are we any luck getting a hold of Mr. Navlet?
And if Mr. Navlet can please speak if you're able to.
Mr. Navlet, sing out. You may have to unmute yourself, but let me know you can hear me.
Judge, oh, there he is, I think.
Are you able to hear me?
Mr. Navlet, is that you?
Yes, hello.
Good morning. How are you?
Good, how you doing, sir?
So far, so good. I'm glad you can hear me. For the record, your name is Nolan Joseph Vince Navlet.
Correct.
I am looking at a statement of defendant on plea of guilty to one count of negligent driving in the first degree, which also involves a dismissal of a hit and run attended charge. Have you gone over the plea form with your attorney?
I have.
You understand if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum, which would be 90 days in jail and or $1,000, regardless of what's recommended by the parties. You agree with that?
Yes.
With that in mind, as to one count of negligent driving in the first degree alleged to have occurred within the city limits of Yelm on March 23rd, 2021, How do you plead, guilty or not guilty?
Guilty.
You make that plea of your own free will?
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find the plea to be freely, knowingly, and voluntarily made, and the statement in paragraph 11 does satisfy the factual elements of the offense. I see the recommendation is, Mr. Dilly, 90 days in jail, all suspended on the condition of law-abiding behavior, and a $500 fine.
That's correct, Your Honor.
Mr. Leone, anything to add?
Anything further? What I can say about Mr. Navale is that he is a small business owner. He's a fantastic individual to work with. He's been very responsive. He's kept great communication with counsel. And I don't think this court will be seeing him again, nor any other court in Washington state will be seeing him again in the future. He is going to be doing some community service. So he is going to be doing a little bit of giving back to the community to repair the wrong done here. And Your Honor, we just request 90 days on the chemical dependency evaluation.
Mr. Davlett, you have a right to tell me anything you wish. You don't have to say anything, but if you'd like me to know anything about the situation, then now's the time.
Yeah, I'm just it was a mistake. It was a time to be able to learn for sure. I'm glad no one was hurt. And I just want to move forward and kind of get this thing over with, and that's it.
Mr. Davlett, hopefully this turns out to be a very, very good educational lesson. Any lawyer, yours, mine, Mr. Dilly, can tell you stories about very prominent people that have put themselves in a position of having badly hurt or killed somebody as a result of doing something they never would have done but for drugs or alcohol. I'm going to follow the recommendation, 90 days in jail, all suspended on the condition you have law-abiding behavior, don't drive without a license and insurance, and pay a $500 fine. Any questions?
Nothing from the defense, Your Honor.
Mr. Navlett, I'm going to wish you the best of luck. I'm convinced by your attorney that you have learned something here, and this is a circumstance that will never be repeated by yourself. Good luck to you, sir.
Thank you, sir.
Concludes the hearing. You can sign off.
Thank you, Your Honor. Thank you, Mr. Dill.
You're welcome. Take care. And Your Honor, I've prepared a motion to order dismiss. Just make sure that's it.
Citing the JNS as we speak.
I think I put it on the JNS that it's dismissed the hit and run.
Okay, perfect.
One error found. I need to find what I did wrong here.
Okay.
Up jurisdiction. Got it.
And then there's a JNS as well.
Oh, I'm on the JNS. I had to put the jurisdiction on 12 months. Specify, you got it. Okay, now we're gonna try. Got it. And
we don't have no one else in the queue.
no one else is in the queue.
No.
Ma'am, you're here for court? Your name is?
I'm Dawn Bateman.
Ms. Bateman, good morning. Fine, this is a motion, I believe. This is with regard to Alan Brown. This is the no contact order issue that arises from time to time. And Ms. Brown does not have Mr. Brown represents himself. Is he going to be here?
See, we just got one phone call in with an ending in 9499.
Let's give that a try. We have a phone number ending in 9499. We don't have a name to go with that. Good morning.
Good morning, Your Honor.
And who am I speaking to?
You speak with Alan Brown?
I didn't quite catch that.
Oh, this is Alan Brown, Your Honor.
Alan Lee Brown. Mr. Brown,
Yes, sir.
you're set for a pretrial hearing on a no contact order violation charge. You're representing yourself in this matter?
So far, Your Honor, yes, I am.
Well, Mr. Dilly is here with the city. Yeah, what you're going to need to do a pretrial is to discuss resolution of the case.
Yeah, maybe I could get his phone number and I could call him next week and we can reset this.
I have a phone.
He has a phone?
Okay, perfect.
And you want to reset this?
Yeah, I haven't had a chance to talk to Mr. Brown.
Mr. Brown, Mr. Dilly has not had a chance to speak with you. We're going to have to reset your case 2 weeks. You're here for a sentence compliance hearing on a previous charge, a data violation December 10th of 2020, as well as a new violation of alleged to be May 10th, 2021. We have your phone number here since you have called in. I don't have it, but Madam Clerk will give it to Mr. Dilly, who is the city prosecutor, and he'll be in contact with you regarding the case. Okay.
Okay, Your Honor.
Mr. Brown will be sending you a notice of regarding today's hearing, and in order resetting the case for a period of 2 weeks. Any questions?
No, Your Honor. I will talk with you in 2 weeks then, and Mr. Dilly before that. And
All conditions previously set remain in effect.
okay, Your Honor.
Did an order, a motion to continue, Your Honor.
Perfect. Let's get back to the. Ms. Bateman, the case has been continued 2 weeks, so we'll see you back here then, if you wish to.
Okay. Thank you, Your Honor.
Yes, so you can provide me with the email address. So we just need your name and your email address. I can send you that info. Okay, thank you. You're welcome.
So what? Ms. Bateman, take care.
Here we go. Step outside.
Donnie, good morning. Donnie, good morning. You may have stepped away from your the computer to take care of something, but hey, I'm hoping you're having a great time in Florida, and hope everything is going as smoothly as it can.
She probably can.
She may have stepped away from.
Yeah.